Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It is Friday morning, the 20th or 21st, maybe the 21st of September. You might know better than me. Anyway, we're going to talk about the Sarah Boone case today, which is due to go to trial on October 7th. The jury selection is due to start on that day, and it might take a day, it might take 2 days. The judge is open to as many days as it takes to get an impartial jury, and then the trial might last 2 weeks or it could go into 3 weeks. All right, well, recently I did a live stream 13 days ago, in fact, Sarah Boone, the suitcase and the battered spouse defence, where I went into the legalities and the problems with the battered spouse defence that Sarah Boone is now trying to claim. Well, yesterday was a hearing, quite a long hearing, numerous motions filed. And the new attorney that Sarah Boone has appointed after she was forced to represent herself because the judge said, listen, we're done with attorney after attorney after attorney quitting. Sarah, you can't keep an attorney, therefore you're going to have to represent yourself. So she did for a while. She couldn't cope. Understandably, she's not a lawyer, she's no legal training. And she advertised for a lawyer, and Mr. Owens took up the challenge. He applied for a continuance of the trial so that he could, learn the case, read the discovery, appoint experts, and that was denied. The judge said, this has gone on for 4.5 years. We're not doing this anymore. So Mr. Owens is now stuck between a rock and a hard place because he's claiming he doesn't have enough time to appoint experts to do everything that's necessary, but he's going to have to manage. He thought that Sarah would take a plea. He thought he could arrange a plea deal between the state and Sarah Boone. That fell through. So he's now forced to go to trial. So here we are at this hearing. Now, they want to now claim self-defence because the battered spouse defence is a form of self-defence. It's not exactly the same, but it's along the same lines. That, you killed someone in terror, in fear, because you felt your life was at threat. That's self-defence, isn't it? Right? It's either me or him. So, it ain't going to be me. I'm telling you now, it ain't going to be me. Now, in the UK, the law states that you're allowed to use reasonable force to prevent a crime against yourself or against someone else. All right. So that's very debated. There was one case I remember where some kids or young people broke into a farmhouse to rob it, and the farmer heard them and had a gun. He shot one of them and they died, and he went to prison. I don't know what the outcome was. I know there was an appeal. I can't remember. Some people might know the outcome of that. Anyway, irrelevant. This is Florida, not the UK. So Sarah Boone has been for a while now claiming that she's a battered spouse. And yes, of course, there is recorded events of domestic conflict between George Torres, the victim, the guy that Sarah put in the suitcase, and Sarah. But it goes both ways. And in a video that I did back in April of last year, The Tragic Suitcase of Sarah Boone, A Psychologist's View, I said what they experienced was what psychologists call either common couple violence or situational couple violence. The terms are used interchangeably, where each side participates in the violence. It's 6 of one, half a dozen of the other. It doesn't mean to say it doesn't get serious. It doesn't mean to say that we can excuse it in any way, either legally or psychologically. But both sides are contributing to the violence, and both sides become victims, maybe at different times. And, it's a mutual thing. The alternative, the other type of domestic conflict is called intimate terrorism, where it's one party who is absolutely terrorising the victim. Like, everything they do is wrong. It's physical, it's potentially sexual violence, it's certainly emotional. It's just horrible, horrible. That's intimate terrorism, and there may be one victim in the family or the entire family. If there's kids and other members, you know, they may all be being terrorised by this one person. But that's not Sarah and George. They were definitely engaged in common couple violence, and when they were drinking, that's when things escalated. Sarah was argumentative. Maybe George was also argumentative. Don't know anything about his character, his personality. So, anyway, she's claiming, right, she's claiming that she was a battered spouse. I don't know of any psychologists in the area that would support this kind of defence. It's insane. The reason being, as I talked about in this live stream right here, that you could be engaged in a conflictual relationship, but then this particular event that happened, right, Sarah zipping him in a suitcase and then refusing to let him out, she's claiming that that's self-defence. Why? Because he was so angry, he was so abusive that she had to force him into a suitcase and zip him up to save herself. Well, that's not what happened, is it? Because we've got the videos, 2 videos that she took in the 11 o'clock hour, where she's goading him, she's laughing at him. She is saying, yeah, because of what you did to me, but it's goading. The only possible way she could claim that this was in any way a battered spouse defence would be if it started off as a game and then she was too scared to let him out of the suitcase. That's not what she said, unless she wants to change the story that she said to the officers who turned up on the day and at the interrogation, which we've also seen. At no point during any of this that's filmed, body cam, interrogation room video that we've all seen, there's no way where she said that she was scared of him. None. She claimed it was an accident.
I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still.
Sarah. Stupid.
So, you play a drunken game of hide and seek. Your boyfriend gets in a suitcase. You zip him up and then go to bed, and the next morning you wake up and he's dead. Is that right, Sarah?
Yes!
Come on now. She went to bed, she forgot about him, and then in the morning she woke up and she thought, oh, F, he's in the suitcase still. There's no self-defence there, is there? That's an accident. That she forgot about him because she was drunk. She forgot about him and he died. A jury might feel that that's not second-degree murder. A jury might feel that that's manslaughter. But then again, the second-degree murder law in Florida kind of applies to this kind of situation. But I'm guessing that the jury will also be given the option of manslaughter. Anyway, yesterday's hearing, and the judge is not happy with this form of defence. And by the way, Mr. Owens is not the first attorney to attempt to use the battered spouse defence. The guy from 2023, I think his name was Bankowitz, he was trying to get an expert to testify on behalf of Sarah Boone that she was a battered spouse. And it was all about the rate of pay that experts would be given. But at the end, he said this.
What's the field?
Spouse defense.
Okay.
Statutorily, we have to give the state notice, sufficient time, and name of the expert and the essential elements that they'll be testifying to.
Mr. Cacciatore, what's your position in regard to the defense request for continuance?
I would have no objection to another role.
So, to be fair to the current defence, the state was put on notice back in April of 2023 that a battered spouse defence was going to be used. So they've had plenty of time to potentially mitigate this. So let's be fair here.
So, Mr. Bankwitz, how deeply have you plumbed the depths of the pool of experts in this field to find out or find one who's willing to work for the JAC rate?
Well, I've actually talked to 3, and but they don't have contracts with JAC and are not willing to work with JAC. And I've made some other inroads with battered women's shelters, trying to get their psychologists, who'd be willing. Problem is willing to testify, basically.
Okay. Because of the concern about the compensation rate for testimony?
Well, that's one of the things. And to be honest with you, this case has had so much notoriety that people don't want to be involved.
People don't want to be involved because this wasn't a case of a battered spouse being so terrified that she killed her partner. It's not that. So you can ignore any previous type of violence that happened and just look at the events immediately leading up to this. And Sarah herself said that they were fine. They were playing games, they were doing puzzles, they were doing artwork. You can listen to what she said. And then they decided to play hide and seek. And George said he wanted to get in the suitcase. She zipped him up. Now, that's not hide and seek. That's weird anyhow. She zipped him up, and then he wanted to be let out. She refused to let him out. And then she went to bed and forgot about him. Accidentally left him in the suitcase. Like, this was intentionality of putting him in the suitcase and then goading him. That's all Sarah. That's on her. But she claimed back in 2020 that she went to bed and forgot about him. Oh, hell, he's in the suitcase still. That's what she said. Anyway, yesterday's hearing. To be fair to the defence, the state should have been aware that battered spouse defence was going to be potentially used. They've had that notice. They've had it. But the judge is concerned about the legality of this. Is this really a case of battered spouse? Is this defence even worth it? So.
But Judge, I agree. There's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Miss Boone about what was going on.
So she's going to testify. That's going to be interesting, isn't it?
But I'd like Mr. Henderson, if you don't.
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally. Correct. And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Exactly the argument I've been making. Because it's obvious.
How is battered?
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Sarah Boone claimed accident. Sarah Boone claimed accident.
What are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
was that the overt act that caused the death?
All of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did.
Therefore, Sarah Boone, the act, is zipping George into a suitcase. But she wasn't in fear when she did that. It was a drunken game. And the only way she could get around this is by saying that she had to leave him in there because he was so angry, he was so incensed that she feared if she let him out, she'd be battered or killed. That's not it either. She made no claims, none, nothing, zilch, nada, none. She made none, zero claims that she was scared of George in that moment, in those hours, at all. So, yeah, let her testify. Let her do it. And let's see what big hole she gets herself into this time. All right, guys, it's a very interesting hearing. Go and watch it. Let me know your thoughts in the comments, and I'll see you in the next video.